Hello all, hope you're doing well today. So today we're talking about harassment and employment expression issues in Chapter 7. And so we'll be talking about sexual and racial harassment in the employment context. It is also exploring discriminatory treatment of employees for engaging in different forms of expressive activity, including seeking justice under the anti-discrimination laws, whistleblowing, violating dress or grooming codes, and engaging in free speech while on the job, as well as observing religious practices and unionizing. As in Chapter 6, the focus in this chapter is on the applicable federal rather than state or local laws. So with this, in the management context in which employment discrimination may arise with the relevant laws and cases, we'll be looking at workplace harassment, under the legal issues of sexual and racial religious issues or harassment, as well as age and disability and sexual orientation. And then looking at some other slews of employment expression and how that affects the workplace as well. So most harassing behaviors are expressive activity in the form of verbal, physical, or pictorial or symbolic statements. Sexual harassment in the workplace can create an abusive work environment that makes it difficult for an employee to perform his or her job. The EEOC, or the EEOC, defines sexual harassment as unwelcome sexual advances or requests for sexual favors and other verbal or physical conduct of a sexual nature where submission to the conduct is made a term or condition of employment, and also submission to or rejection of such conduct is used as basis for employment decisions. The conduct has the purpose or effect or unreasonably interfering with an individual's work performance. The conduct has the purpose of creating an intimidating, hostile, or offensive working environment. Now, there are two types of sexual harassment. One of those is quid pro quo harassment, which occurs when an employer conditions a job-related benefit, such as promotion or pay raise, upon an employee's willingness to engage in sexual behavior, so sexual bribery. The second one is a hostile environment, which is really more difficult to define and address. Employees are subjected to repeated unwelcome behaviors that do not constitute sexual bribery, but are severe and pervasive that they create a work environment so hostile that it substantially interferes with the harassed employee's ability to perform their job. Courts look at the frequency and severity of the conduct. Conduct may be physically threatening or humiliating or offensive. The conduct unreasonably interferes with an employee's work performance. There is a two-pronged test for hostile environment. One of those would be would a reasonable person in the same situation have perceived the climate as hostile? Did it create a hostile environment, making it difficult to perform their job? Now, there's another, moving on to racial harassment. That is one that's been in the workplace for quite a while and still continues to be. We also have same-sex and same-race harassment. So harassment is not just based upon sexual orientation, but is harassment of a sexual nature perpetrated by a person of the same sex. Title VII does protect transgender people. We've actually seen that come about with the new bathroom laws. And so giving a little bit more protection in that area, and how that trickles down into other laws and rules, if you will, of just social issues. Employment Non-Discrimination Act, or ENDA, prohibits employment discrimination based on gender identity and sexual orientation. And employer liability. So what can we do to protect ourselves? One of those is to have affirmative defense, which is a defense that excuses rather than blames. by showing, number one, that the employer exercised reasonable care to prevent and promptly correct any sexually harassing behavior. Number two, the plaintiff employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer. So, some conduct that may contribute to a sexually hostile work environment: unwanted touching, pinching, patting, or hugging, whistle or catcalling, sexually suggestive or obscene notes, letters, or emails, and leering or sexually oriented gestures, obscene jokes or vulgar language, and display of sexually suggestive materials. I think we all can say that we probably have gotten and even sent on email, or maybe it's something Facebook or something along that line that might be considered, that could be sexually suggestive as such. And so we have to be really careful in what we're sending on and what kind of work environment we are in with that. So the text states that many possibly harassing behaviors fall into a gray area, and courts must make a judgment call. We must make judgment calls also about what we see every day. So imagine that you see a men's magazine with a cover showing a scantily clad model in a professor's office. Would you object? What if the scantily clad model were on a poster in a friend's dorm room? Would you object then? So I think you have to look at the context of where it is and what it suggests to everyone. So, and why or why not would you think that? Now, looking at some advantage strategies for sexual and racial harassment. Number one, adopt a harassment policy that is separate from your general anti-discrimination policy, and disseminate, explain, and enforce it. Really important that oftentimes we may have policies but we don't disseminate that information. We don't explain it. We don't enforce it. Really important that you talk about it and that everybody knows where you stand on this and what you plan to do about it. You also want to make sure the policy covers racial and religious harassment in addition to sexual harassment. And when including definitions of prohibited behaviors in the policy, make the definitions broader than what it is defined by the law. That covers your basis. And do not assume that everyone understands what sexual harassment is. It's really important to conduct workshops to educate people on what sexual harassment is. I think oftentimes, we can get to joking with one another and not realize that that could be something that might be, and maybe not sexual harassment, but maybe harassment in some form or fashion. So we have to be careful of how we're conducting ourselves is really what it amounts to. So there's some essential elements of a harassment policy. Number one, that there is a philosophy of zero tolerance. So you have a harassment policy set up and you are following up on it. You are enforcing it and educating about it. There should be a description of the legal definition of sexual, racial, and religious harassment with examples. You should have clear reporting procedures so people know who to go to if they feel like something is going on. And you also should have a description of the investigation process so that they understand how things are going to go, how things are going to be investigated. And also a description of sanctions or disciplinary actions, along with an appeals process. So sometimes employees provoke adverse employment actions by the way they choose to express themselves in the work environment. Title VII protects employees from employer retaliation for the employee's efforts to obtain justice under the statute, including whistleblowing. So oftentimes they're seeking justice, and they're doing that by whistleblowing. They see that something is not right in the workplace, and they are wanting to make it right. And so oftentimes to do that, they have to tell someone, and someone up above or someone outside of the organization, and letting them know that this is what's going on in the organization. There's also dress and grooming codes. And the private sector, courts have ruled that employers may impose reasonable rules governing the appearance of their employees without running afoul of the sex discrimination provision for Title VII regarding appropriate hair length and appropriate clothing for the different sexes. Grooming or dress codes that differentiate on the basis of race or sex, and that subject matters members of those groups to follow conditions of employment as a result, such as requiring females to wear skimpy clothing. Oftentimes you'll go somewhere, and to identify themselves as an organization, they're all wearing the same. They have a dress code, and so they'll have shirts with the name of the organization on it, and so the courts really they see that as being reasonable, and your employees wearing the same clothing. However, if you've got men, there's no such rules on men, but there are for women. That conjures up a little different scenario. Injudicious speech. We'll talk a little bit more about that in a moment as well. Religious speech, and this could include team prayer and religious practice. And then unionizing activity. Section 8A3 of the National Labor Relations Act, or NLRA, makes it an unfair labor practice for an employer by discrimination in regard to hire or tenure of employment to encourage or discourage membership in any labor organization, professional athletes' involvement with player association. So what are your thoughts on dress codes? Do they stifle freedom of expression and suppress one's style and culture? Or do they help diminish economic and social barriers, such as in schools, and promote a sense of belonging? You've probably all been at school, and you can definitely tell who the haves are and who the have-nots are, and how that can create those social barriers in school, or the mean girl syndrome, things of that nature. Now, the Pickering balance test is one that it is used in the case of injudicious speech and whistleblowing. The First Amendment protects the right of federal state government workers to enjoy freedom of speech when speaking as citizens on matters of public concern. A matter of public concern, which would be like social or politicalized ideas, depends on examining its content, form, and context, and the role of the speaker when the statements were made. So the Pickering test balances the interest of a citizen and employee commenting on matters of public concern versus the interests of the government employer in promoting efficiency of its services. So depending upon, again, the context of when the message was said or the speech was given, if you're on the clock and you're employed, then it's a little bit different than if you're off the clock. So those are some things to consider as well. So in your opinion, how far should the right of free speech extend? Should you be able to say anything you want, whenever you want, even if others find it offensive? I find right now a lot of things offensive with the political tirades that are going on, and the presidency, the run for presidency. And I don't know. I'd be interested to hear what you guys have to say as well. What if potentially offensive language was used in the course of official job responsibilities? It's really scary to me to think that we may have someone in the presidency that is offensive and offending others. Puts things in a little different light. So, determining reasonableness of religious accommodations, the First Amendment also protects our freedom of religion. Two clauses. Number one, free exercise clause protects our fundamental right to the free exercise of religious beliefs unless those beliefs illegally cause harm to society. And then the Establishment Clause, which was intended to prevent the establishment of a government-endorsed religion. The government must be neutral with respect to religious matters, and therefore employees expressing a religious viewpoint or taking a political stance that is informed by a religious perspective. So religious speech can take the form of prayer in the case of team prayer. There are 3 tests for the Establishment Clause. One of those is the endorsement test. When you are endorsing religion or leading, selecting, orchestrating, or participating in religion. And in that case, they look at the history and context of the behavior and ask the question, what would a reasonable observer do? Number 2 is the coercion test. And the number 3 is the limit test. So religious expression may arise in the employment context in situations where an employee refuses for religious reasons to adhere to an assigned work schedule that conflicts with the observance of a religious holiday or an employer's policy regarding appropriate conduct, dress, or grooming. It need not be an organized or recognized religion. In fact, atheism is considered to be a religion as such. So in determining reasonableness of religious accommodations, you look at the size of the staff, the employee's job, whether other employees were asked for the assistance in making the accommodation, and willingness of others to make the accommodation, as well as cost and administrative burdens. And then what has been done by similarly situated employees. And so looking at all of this, you're looking at context, how things were done. Does it create a lot of burden on the organization? And are you willing to accommodate is basically what it amounts to. So some competitive advantage strategies for employee expression. Be sensitive to cultural differences that may affect the work environment. You have to be careful in asking about those things when you are hiring someone, but once you have hired them, just being aware of them is important in helping to accommodate them. Respect the views of your employees and encourage them to offer criticism constructively. And oftentimes you can learn from one another about the differences and share those things as well. So that is it for today on harassment. I hope you've enjoyed it, and we'll talk more about Chapter 8 tomorrow. Thanks so much. Have a great day.